Hello, welcome back. This is Roger Royce, host of the 10,000 Startups podcast, Legal Strategies for Startup Success. I'm a partner with the law firm of Haynes, Boone in downtown Palo Alto. Today we have another Haynes, Boone lawyer talking to us about trade secrets. It's all about trade secrets. What are they? How do you protect them? Why are they valuable? What happens when things go wrong with trade secret? So I'd like to welcome Kevin Crisp here. As I said, he's a litigator in our Orange County office of Haynes Boone, and he litigates these issues. So he's usually on the other side of trade secret when something goes wrong, or when somebody wants to challenge it, or someone tries to steal it, which that happens sometimes, right, Kevin?
Absolutely, yes.
So Kevin, tell us, first of all, maybe tell us a little bit about your background, and we'll just launch into this.
Yeah, absolutely. As you said, I am a litigator. I have litigated all sorts of commercial litigation disputes, but certainly a number of trade secret fights. They come up, unfortunately, more often than my clients would like, but they tend to be interesting cases for me. I enjoy them a lot. I've been a lawyer for 15 years. Before that, I was a banker. So a lot of my cases also have a lot of financial and accounting aspects to them. That tends to be my wheelhouse.
Okay.
Anyways, happy to be here. Thanks for having me.
Okay, great. Well, let's just answer the first question for everybody. What the heck is a trade secret? Why is this even a thing?
That is both a great question and a loaded question. Mostly because almost anything can be a trade secret. The law is somewhat vague and sometimes circular. But to try to describe what is a trade secret, the best place to look is the Uniform Trade Secret Act, which has been adopted in essentially every state except for New York. North Carolina has a slightly different version of the statute, but otherwise that's it. The statute defines a trade secret as any information that derives economic value from being confidential. That, of course, doesn't necessarily narrow things down as to what is the trade secret. That's really just sort of, did you keep it confidential? But there is some guidance in the statute as well as from the case law. Basically, it can include things like formulas. The archetypical example is always the formula for Coke, Coca-Cola, right? A very famous trade secret. It can be a pattern or a compilation. We very often run into compilations of otherwise public information as trade secrets. It can be a program, it can be a device, a method or technique, a process, really all sorts of things. In my practice, I have often run into client and marketing information as a trade secret. And again, that's the kind of information where some of it might be publicly available, but it is the owner of the trade secret, their own particular compilation, the efforts they put into putting that information together that makes it protectable as a trade secret. I've also run into cases where training materials are trade secrets. For a lot of companies, the ability to train their employees efficiently and effectively gives them a competitive advantage, and their various training materials, processes, methods, and so forth can be protected as a trade secret. And I've also worked with a lot of companies where their financial information or financial analysis is a protectable trade secret. And again, these are the types of information that might be derived from public sources, but the particular compilations of that information is what makes it protectable.
Boy, that's a lot. That's a broad category. So to give the audience just some guidelines, what I always tell people is I say, look, it's three things. Number one, it's gotta be secret,
Yep.
as you might expect. Number two, it's gotta be valuable, which usually those first two prongs, okay, we get that.
Yep.
The third one, though, is that you, the company, you have to have taken some sort of measures to protect its confidentiality. And it's that third prong that if someone's going to trip up, they're going to trip up on that. And I tell them, look, you should have NDAs in place. If you don't do that, doesn't look to me like you're trying very hard to protect your trade secrets. You should have like a security system in place, so not everybody in the world can get into your database or code base or whatever it is. You
Yep.
shouldn't be publishing it on Zoom calls in public, stuff like that. Can you expand a little bit on that third prong? Because I think that's where the real tension is.
Yeah, and again, sort of notes on a theme here of the law for trade secret being vague and circular, right? And so what the law requires is that you take reasonable steps to maintain the secrecy or confidentiality of your trade secret. Again, vague, right? And it can depend on the circumstances. It can depend upon the nature of the information, how it's stored. It can depend upon industries. I've had cases where you have industry experts describing, well, here's what people in this industry do to keep information secret, which might be different from a different industry. But you're absolutely right. There are some basics that no matter what industry you're in, you have to be doing. And of course, the best thing is to do everything you can within reason, right? To maintain confidentiality. You mentioned number one, absolutely, non-disclosure agreements, NDAs, right? You got to have NDAs with anyone who might have access to the trade secret information. This usually includes employees, but it can also include independent contractors or really anyone who might have access to the information, however it's stored. It's also really important to have thorough policies and procedures, right, documented in handbooks and acknowledgments, right? And it's important to regularly monitor and enforce those policies and procedures. And again, these are vague terms. The specifics matter on how you're storing your information, right? If you've got information in hard copy, right, that's going to be different than how you deal with information that's stored electronically, right? Or sometimes there's information that you communicate in person that you still want to maintain as a trade secret, and how you deal with the confidentiality of that information can depend upon all three of those methods. So for example, any information that you want to keep a trade secret that's in a hard copy or paper version, you've got to stamp every page of that confidential. It's a really easy, low-cost thing to do, and most courts are going to require it. And the failure to do that is potentially damaging to your trade secret rights. Similarly, just basic security, right? It's storing information in hard copy. You're going to need locked doors, right? Your premises are going to need to be locked. You're going to have basic security that you're going to have to point to and defend if you go into trade secret litigation. For electronically stored information, you're going to need information to be password protected. It can be very useful to have click-through agreements. So if you have employees or others who are about to access information that you want to keep it protectable as a trade secret, have every time they access it a pop-up box with a click-through agreement that says they understand this information is confidential and they're going to keep it confidential. And then, I mentioned in-person presentations. As I said earlier, I've had cases where training materials are trade secrets, right? Well, that means you're often doing it in person, or these days, virtually in-person presentation, right? So at the beginning of every session, a verbal statement, usually recorded, that this information is confidential and to be treated as such, and then acknowledgments and written acknowledgments from your audience that it's going to be kept confidential. And again, these are just some of the examples of the basics, right? Which I think probably brings back to something that I think probably comes up a lot, Roger, which is talk to your lawyer, get some advice.
Yeah, there you go. As you're describing all these measures to keep things secret, there was kind of a famous case here a couple of years ago during COVID. Everybody went to Zoom, right? Not everybody knew how to use Zoom. And there was one company, court came and ruled that they had lost their trade secret protection because they talked about it on a Zoom call, and the Zoom call was open to the public. Anybody could have joined. So just shows you how fragile trade secrets can be.
Absolutely. And that's a good point, which is another thing you've got to do to protect the confidentiality of your information is things are going to slip through the cracks, which means when they do, you immediately react and you claw back information, or if it's inadvertently produced in some sort of way, you go try to undo it and make some sort of effort. If that breach occurs and you do nothing, that will be Exhibit A against you in your trade secret litigation.
Yeah. So stepping back a little bit, you mentioned the Coca-Cola formula. And I love that example for a lot of reasons, but one is that, let's suppose Coca-Cola had just patented its formula instead of relying on trade secret. Well, two things. One, that would be public information. And number two, it would have expired a long time ago because the patent's 50 years and Coke's been around for, more than 100. So that's a really good example of a kind of piece of intellectual property that is better protected under trade secret law than patent law, which raises the big question, how does an entrepreneur know? Should I rely on patent? First of all, what's the difference between a patent and a trade secret? Which one is more appropriate for my process, formula, know-how, invention, etc.?
Yeah, really great point, right? If Coca-Cola had patented the recipe, however many decades ago, we'd all be drinking free Coca-Cola, except it wouldn't be called Coca-Cola today, right? There'd be generic versions of it everywhere. And so to start with, right, the difference between patent and copyright, perhaps on the one hand, and trade secret on the other, the big obvious difference is one is secret, one is public. One of the main requirements of a trade secret, as we've been discussing, is that it be a secret. One of the main requirements of both patent and copyright is publishing, the exact opposite of secrecy, right? And there are various reasons for this, right? We give all sorts of rights to patent and copyright owners, basically in exchange for them publicizing, the owner of that intellectual property, publicizing their creation so that society can benefit in some way from that publication. But that does mean, as you've rightly pointed out, someone who has created some piece of intellectual property, they've got to decide what it is they're going to do with this intellectual property. And are they going to protect it with trade secret on the one hand, or are they going to protect it with copyright or patent on the other hand? There are certainly multiple considerations. You touched on one of the very first ones, which is the length of time in which you will get property rights in your creation. Patent, I believe, is 20 years, and copyright is generally 70 years. All sorts of exceptions on the copyright length, as well as on copyright protections. Whereas trade secret can be forever, or so we assume. That's one consideration. Another consideration, though, is really the type of information that you have and the type of industry that you're in. I think a lot of business owners imagine that they're going to be in business for longer than 20 years at the outset, full of optimism, no matter what. And so that the timing, might be that, they go, this is a very valuable piece of information. I want to protect it forever. But it may be that there are, reasons why you want to get patent instead. But what I come across more often is the types of information that gives a company a competitive advantage because the information is secret, right? And publishing it in some way diminishes the value. Again, we went back to the definition of a trade secret, right? And so in that way, again, a really good example might be training materials, right? And then the question the owner of that information has to ask themselves is, how do they want to monetize that information, right? If they want to go publish the training materials and sell books, great. Go be a publisher. Go be Penguin Books and publish books. But usually they've created these materials in some other industry, where it's giving them a competitive advantage in that industry by keeping that information to themselves, right? And so sort of the nature of the information itself drives the answer, and the nature of the business itself drives the answer.
Okay, thank you. Thank you for that description. So let's suppose now so now we've got trade secrets and we're doing everything we can to protect them. We know what we have to do, but like you said, it's going to get out. And especially here in California, there's such an overlap between just employment law and trade secret law, because I always tell clients, when your employees walk out the door, your trade secrets walk out the door too. So is there anything we can do to protect ourselves? Because corporations can only act through people, right?
Yes.
Somebody in the organization has to know something about it, right?
Yes.
What do we do to protect ourselves from bad employees who are going to take our trade secrets across the street and commercialize on them?
Yeah, at the end of the day, your idea locked in a safe, and to continue the theme, right? A safe in some office in Atlanta doesn't necessarily do you a whole lot of good, right? You've got to share it with somebody in order to use it in your business, and whether that's share that with employees or others, right? It's usually employees, right? So you've got to enforce, again, reasonable efforts to maintain confidentiality. Number one on my list of that is when you have employees, again, we've talked about in the front end, getting non-disclosure agreements. You've already got those in place. When an employee leaves, right, send them a continuing obligation letter or continuing obligation checklist. Remind them of their obligations. Remind them and document that you're telling them, hey, they've had access to information. It's confidential, right? We talked earlier about communicating with your lawyers when need be. In this case, communicating with your employees is critical, right? Communication is key, but you're also documenting in case things do go sideways, right? This will just be another exhibit, another trial exhibit, right? If need be, hey, I reminded you that this was confidential and you went and breached it anyways. But better yet, by communicating in that way, hopefully you head off at the pass any potential problems. And hopefully your former employees are willing to communicate back to you.
Right. Yeah, I call that a termination certificate.
Yes, exactly right. That's it.
And the way I'd set it up is say, hey, look, you're leaving. We're going to pay you some severance, but in exchange for that, we're going to pay you. But what I want from you employees, I want a release, first of all, and I want this termination certificate where you swear to me right now that you haven't taken any of your trade secrets. So they have to lie.
Yep, that's right. So you get your representations and warranties. And since you mentioned the release, while you're getting that release, before you enter into that release, do a little bit of due diligence, right? Have your IT people check to make sure that your soon to be former or now former employee, as the case may be, hasn't just downloaded a whole bunch of information or sent a bunch of information via email to themselves. Because if so, you're going to want to deal with that before you exchange the releases, right? And by the way, that sort of due diligence is something you probably want to do with any employee who's leaving who might have had access to your trade secrets.
Yeah, and if you're the employee, you're going to leave, you'll found your own company, you have to assume complete transparency.
Yes.
You just have to assume, because I can tell you every well-advised company is going to know everything that's on your company computer. They're going to look at it very hard. They're going to look at your profile to see what you're doing next. You have to assume complete transparency. And, here in California, we've got a rule that will protect some of the stuff you developed, our labor code, right? Where if you develop it on your own time and it doesn't relate to your employer's business and use your own facilities, and it really, in essence, wasn't the thing the employer hired you to do, then maybe that belongs to you and not the employer. But, make sure you've got really good documentation for when things blow up.
Again, notes on a theme as far as communicating with your lawyers, right? If you're leaving to found your own company, right, get some good legal advice. And you're absolutely right, Roger. Assume that everything you're doing is being monitored, especially everything that's on a computer.
Yeah, for sure. So following up on that, on the enforcement side, let's suppose that somebody does steal trade secrets. They've left. a lot of big kind of cases in the news, pretty much constantly about this happening. In fact, just Google the Waymo cases and you'll see hundreds of millions of dollars of liability for allegedly stealing trade secrets. I don't want to get in trouble here.
Sure.
So tell me about a trade secrets case. You're an employer, or you're a company, and somebody, either it's an employee or some other bad actor, has taken your idea and all the stuff that you've clearly protected as a trade secret, and now they're exploiting it. What can we do to stop that?
It's not even just what can you do, it's what must you do, because again, secrecy is the cornerstone of trade secret. So if someone has taken your trade secrets or somehow obtained them, right, and you know about it and don't do something about it, that in and of itself might be used against you as evidence that you forfeited all property rights in that trade secret. And so that's why also not only do you then start off with, obviously initially a letter, right, that says, hey, you have my information, it is confidential, it is a trade secret, cease using it immediately, return it all immediately, right? And it has to be quick, and it has to have a quick deadline, right? Because again, time is of the essence, and you are proving to a future court that you make reasonable efforts to maintain the secrecy of the information. If the information is not returned, or you don't have satisfactory evidence that the information has been returned, you've got to follow up with an action. It can be a lawsuit, it can be an arbitration, right? It might depend upon the relationship you have with the wrongdoer. But it probably needs to include some sort of request for preliminary relief, a temporary restraining order, and a preliminary injunction, because trade secret information being used pending the case, right, is something that you have to stop, or again, your failure to request that preliminary relief can be used against you as a failure to make reasonable efforts to maintain confidentiality of the information.
Can we pause on that? So again, what is equitable or injunctive relief? How's that different than money damages?
Yeah, so good question. First and foremost, in this situation, it is a court order telling someone to do or not do something, right? As opposed to damages, which is, hey, here's some money to make you whole, right? And in this case, it is a remedy that you're getting preliminarily. You're getting it at the outset of the case as opposed to the end of the case. And there are various things you have to prove to get that. But an alleged breach of trade secret is one of the cases where you more often than not can get preliminary relief, precisely because, as we've said, the breach of the secrecy is in and of itself damaging and cannot necessarily be remedied with just money damages, because once the cat's out of the bag, you can potentially lose all your property rights forever.
Yeah, your company's done. So this preliminary relief, can you do that ex parte, meaning without even telling the other side, just marching into court and saying we haven't?
Depending on the circumstances, yes. But bear in mind, that is the TRO, the temporary restraining order that a court might enter, absent the other party having answered and said why maybe the TRO should not be entered yet. And usually, if that's the case, the preliminary injunction, which comes in next, a hearing and briefing will be set on that very quickly, often within weeks. So that way the other side now can come in and say, hey, here's why the TRO should be lifted, and or, no preliminary injunction should be entered.
Okay, gotcha. Well, anything else our startup founders and entrepreneurs should know about trade secrets before we wrap up?
Yeah, so the other thing that I think a lot of entrepreneurs run into is not just when they leave their former shop to hang their own shingle, but when they start growing and hiring employees, because they can ultimately be vicariously liable or even directly liable if their new employees bring trade secrets with them. So they're now on the flip side of this, and sometimes they got to make sure their new hires are not bringing trade secrets with them that they shouldn't have. So this includes now the pre-employment obligation letter, right? Hey, if you have trade secrets, don't bring them. It may include, for a lot of industries, if you're talking about employees who are outward facing salespeople, right? Being careful about the way in which you announce your new hire. We call these tombstone ads, where you simply publicize that you have a new employee, and here's where they're working now, right? And then being careful about reconstructing client lists from public information and documenting that. And again, notes on a theme, communicating with your lawyers, right? These are moments where it's worth it to send Roger an email and say, hey, what do I need to be thinking about here? So that way, you get some good advice and you can follow it.
Yeah, let me just pause on that before we wrap up. But the usual dance that I see is employee leaves, they start a new company. So former employer, they send a shot across the bow, it's a letter, or they join a new company and they say, hey, I want to remind you, you signed a confidential information agreement and invention assignment with us. And we're going to enforce that aggressively if you take any of our trade secret. And then, of course, the answer, again, on the other side, is to send a letter back saying, we would never dream of taking any of your trade secrets. We know all about it. In fact, we are so diligent. We made that employee that came over sign a document promising he's not bringing anything.
Yep.
And we all put that in a file and hope nothing bad happens.
Exactly right. You both got your exhibit A's. So, and then the last thing I'll say, if I may, I have run into this in cases before. Sometimes we don't know what we're taking with us when we go from one place to another. I've seen this before, in particular, in the electronic data age. You don't necessarily know what's deep in your email or on USB drives or on computers or whatever. And it can be worth taking a look because in particular, people who use even occasionally personal email for business work, right? That email that's now, for example, deep in your Gmail from 7 years ago might have in it some trade secret information. And if you end up in a dispute and that comes out, that could be used against you, even though you have no idea you have it. So a little bit of due diligence. And again, call Roger up and ask him and say, hey, here's the event. What do we need to do? Right.
Okay. Well, I want to thank you very much, Kevin, for being here and telling us everything that anyone ever wanted to know about trade secrets. We've really sort of scratched the surface, in effect.
Absolutely. My pleasure. Thank you so much for having me, Roger.
Yeah, and it's a really good summary. And out there, if you are a founder and if you do have this issue, Kevin Crisp in our Orange County office at Haynes Boone, he litigates trade secret matters. He helps you enforce them, protect them, or defend if you happen to be on the other side of somebody.
Absolutely.
All right. And with that, this is Roger Royce, 10,000 Startups, and we will see you next time.